Case 1. Shanisha Taylor. March 20th, 2014. Scottsdale, Arizona, connected to a broader national conversation about poverty, desperation, and the criminal justice system that resonated deeply across Detroit and Michigan communities facing similar economic crises. There are cases in the American true crime landscape that divide the public almost immediately. Cases where the line between tragedy and criminality becomes difficult to locate, where poverty and desperation collide with the law in ways that no one fully prepared for. The case of Shanisha Taylor is one of those cases. It is a story that generated more than $100,000 in public donations, sparked congressional-level debate about child care policy, trended nationally on social media, and ultimately became one of the most discussed parenting and criminal justice stories of 2014. But at its center, underneath all of the noise and all of the debate, were two very small children, left alone in a vehicle on a scorching Arizona afternoon, and a mother whose choices on that single day would change her life and the lives of her children forever. Shanisha Taylor was 35 years old in the spring of 2014. By her own account, and by the account of investigators who looked into her situation, she was a woman in genuine crisis. She was homeless. She had 3 children, a daughter who was 9 years old and 2 young sons, one who was just 6 months old, and one who had recently turned 2 years old. She had been moving her family between relatives' homes and her own vehicle for months, unable to secure stable housing or steady employment. She was, in the language that social workers use, a woman caught in what researchers call the cycle of compounding disadvantage, each problem feeding into the next, making every solution harder to reach. On the morning of March 20th, 2014, Shanisha Taylor had a job interview scheduled at an insurance company in Scottsdale, Arizona. This was not a casual appointment. According to Taylor herself, she felt that this particular interview represented a genuine turning point, a real opportunity to stabilize her family's situation, to get off the streets, to provide a real home for her children. She had arranged for someone to watch her 2 youngest sons while she attended the interview. At the last minute, that arrangement fell through. The caregiver did not show up, and Taylor was faced with what she would later describe as an impossible choice. Do you pass up the interview that you know is going to save your family? Taylor would later say in a nationally televised interview on The Today Show, do you pass up the interview you know is going to give you a future? It's a desperate moment where you decide, do I provide for my children? Do I provide home, shelter, food, necessities? Or do I stay here and do I care for the children? Taylor made the decision to take her 2 youngest sons with her to the parking lot of the insurance company. She placed them in their car seats inside her Dodge Durango. She cracked the windows open approximately 1 inch. She left the keys in the ignition, and she went inside to interview for a job she believed would rescue her family from the streets. The interview lasted longer than expected, approximately 1 hour. It went well enough that Taylor later told reporters she felt she had the job in the bag. She walked out of that building feeling, for the first time in a long time, like things might actually turn around. What she found in the parking lot told a different story. Police vehicles surrounded her Dodge Durango. Officers were already on the scene. A woman who had been on her lunch break had walked past the vehicle, heard a child crying inside, and called 911. According to the Scottsdale Police Department, the temperature inside the vehicle had climbed well above 100 degrees. Responding officers found both children still strapped in their car seats. The 6-month-old infant was wearing a short-sleeve shirt layered over a long-sleeve shirt, with a blanket on top, dressed far too warmly for the heat that had built up inside the vehicle. Both children were sweating and distressed. The infant had been crying. The windows were rolled down barely an inch. There was no running air conditioning inside the vehicle. I felt lost at that moment, Taylor would later say. Like everything I had built myself up for, everything I was trying to do, had fallen apart. Scottsdale firefighters and officers removed both children from the vehicle. Shanisha Taylor returned to the parking lot to find herself under arrest. She was charged with 2 counts of felony child abuse by the Maricopa County Attorney's Office. Prosecutors argued that regardless of her intentions, regardless of her circumstances, she had placed her children in a situation that created a serious risk of harm. And under Arizona law, that was a criminal act. The image that defined what followed was her booking photograph. Shanisha Taylor's tearful mugshot. Her face wet with tears, Her expression, a mixture of devastation and exhaustion, spread across the internet within days of her arrest. For many people who saw it, that image told the story of a woman who had made a desperate choice, not a calculating one. For others, the image was irrelevant. The law was the law, and children had been placed in danger. A crowdfunding campaign launched by a New Jersey woman named Amanda Bishop, who said she simply could not stop thinking about Taylor's photograph, raised more than $114,000 in a matter of weeks. Strangers from across the country sent money. The story dominated national conversation about poverty, the lack of affordable child care in America, and what the criminal justice system should and should not do with mothers in crisis situations. The legal journey that followed was long and complicated. In April of 2014, Taylor was formally arraigned on 2 felony counts of child abuse. She entered a plea of not guilty. In July of 2014, Maricopa County Attorney Bill Montgomery announced a plea agreement. Taylor would avoid prosecution entirely if she completed a minimum of 26 weeks of parenting classes, underwent substance abuse counseling, and established a trust fund using $60,000 of the donated money, with half designated for child care and half for her children's future education. Taylor described the deal as a second chance that she would not waste. "Not many people get the opportunity that I have," she said at the time. "So I'm grateful." She regained custody of her children in September of 2014. Her daughter, then 10 years old, had been teased at school by classmates who had seen her mother's name in news coverage. Taylor said the road back had been enormously difficult, not just legally, but personally, emotionally, and practically, since she still could not find a job in the wake of the national attention the case had received. But the story did not end cleanly. In November of 2014, the Maricopa County Attorney's Office announced that Taylor had failed to meet the deadlines for establishing the trust fund. Court records that became public around the same time revealed that Taylor had been spending approximately $4,000 per month from the donated funds, including $1,038 for rent, $500 for food, $250 for gas, and $275 for cable and internet. Prosecutors said their patience had reached its limit. The possibility of reinstating the felony charges was placed back on the table. Her attorney withdrew from the case in early November. A trial date was set for December 10th of 2014. The Shaneshaw Taylor case became one of the defining stories of 2014 because it refused to be simple. It raised genuine, unresolved questions about whether poverty itself is being criminalized in the American justice system. It raised questions about what constitutes adequate child care infrastructure in this country. It raised questions about the expectations we place on parents, particularly single mothers, who are struggling to survive in an economy that does not provide them with adequate support. And it raised questions about what the courts are actually designed to do: punish, rehabilitate, deter, or protect. What it never became, despite all of the complexity, was a case where anyone could honestly argue that 2 small children had not been placed in genuine danger on a hot Arizona afternoon. The children were real. The temperature was real. The risk was real. And the grief on Shaneshaw Taylor's face when she walked out of that interview and saw those police vehicles, that was real too. The case remains a reference point in national discussions about child care policy, criminal justice reform, and the intersection of poverty and parenting in America. Child advocates have used it as evidence of the desperate need for expanded, affordable child care options. Criminal justice reformers have used it as evidence of a system that punishes the poor for problems that policy could solve. Neither side has been entirely wrong. The children in this story deserved safety. Their mother deserved support. The tragedy of this case is that, on March 20th, 2014, neither of those things was available at the same moment, and the result was a courtroom, a mugshot, and a national debate that still has not been fully resolved. If there is a lesson here for every community and every level of government, it is this: the systems that are supposed to support struggling families must be stronger, more accessible, and more responsive. Because when those systems fail, it is always the smallest and most vulnerable people who pay the highest price. Justice, in this case, was complicated. But the conversation it started, about child safety, economic inequality, and what it truly means to protect children in America, that conversation still matters. And it still has not been fully answered. If you are finding this documentary valuable, Please take a moment right now to like this video and subscribe to Cold Case Time. Your support helps us continue bringing these important stories to light. Hit that subscribe button and the notification bell so you never miss an episode. Case 2. Brandy Pierce. October 24th, 2024. Detroit, Michigan, the 19,700 block of Woodingham Drive, northwest side of Detroit. There are cases that make experienced prosecutors pause. Cases that make veteran investigators, people who have spent entire careers confronting the very worst of human behavior, stop and say words they almost never say. This is one of those cases. In the winter of 2025, a landlord in Detroit made a discovery while preparing a rental property for a new tenant, a discovery that would shock the city, stun the nation, and place a 41-year-old Detroit mother at the center of one of the most disturbing child welfare cases in Michigan history. The landlord was doing routine work at the property on Woodingham Drive when he noticed something in the backyard that should not have been there. Something that looked, unmistakably, like a small human foot protruding from the ground. He called the police. What Detroit police officers discovered when they arrived at that property on January 6, 2025, was a shallow grave in the backyard of the home. Inside that grave, wrapped and buried, were the remains of a child. The Wayne County medical examiner would later confirm that the child was 9-year-old Zemar King, and that his death had been a homicide. The details that investigators pieced together in the weeks and months that followed are among the most disturbing in recent Detroit history. Brandy Catrice Pierce, 41 years old, had been Zemar's mother. According to the Wayne County Prosecutor's Office, Zemar King lost his life on or around October 24, 2024, inside the Woodingham Drive home, where he had been living with Pierce and his 3-year-old brother. Prosecutors allege that Pierce fatally harmed her son, then purchased a shovel, bound Zemar's hands and feet together, dug a hole in the backyard of the property, and buried him there. She then allegedly abandoned the home entirely and drove to Georgia, taking only her 3-year-old son with her. She left Zemar behind in the ground. For weeks, no one knew. The home sat quietly on Woodingham Drive. The landlord had no idea what had happened. Neighbors had no idea. The schools that should have been expecting Zemar did not know where he was. In a heartbreaking detail that would emerge later in the legal proceedings, it would be revealed that Zemar King was not an entirely invisible child. He had, in fact, tried to tell someone what was happening to him. In April of 2024, approximately 6 months before his death, Pierce had taken Zemar to a hospital. Child Protective Services workers were called in during that visit, and Zemar King, 9 years old and sitting in a hospital room, told those CPS workers something that should have changed everything. He told them that his mother choked him, that she wanted to kill him. Those words, spoken by a 9-year-old child to the very people whose job it was to protect him, would later become one of the most heartbreaking details in the entire case. Because Zemar went home, and 6 months later, the landlord found his foot sticking out of the ground. In December of 2024, the Brookhaven Police Department in Atlanta, Georgia, opened an unrelated investigation involving Pierce and her surviving 3-year-old son. That investigation prompted them to alert the Detroit Police Department. Detroit investigators connected the dots and began looking into Zemar's disappearance. On January 6, 2025, when the landlord found the shallow grave, the investigation accelerated rapidly. Pierce was located and arrested in Georgia on January 10, 2025. She was taken into custody in Cobb County. The 3-year-old son was placed in Georgia foster care. Pierce was extradited to Michigan and transported back to Detroit on January 12, 2025. On February 27, 2025, Brandy Catrice Pierce appeared before Judge Delphia Burton in Detroit's 36th District Court for her formal arraignment. She appeared via video. A magistrate entered a not guilty plea on her behalf. She was held without bond. Wayne County Prosecutor Kim Worthy, who has prosecuted some of the most serious child abuse cases in Michigan history, stood before cameras and said something that stopped the room cold. "I have been a prosecutor for a long time," Worthy said, "and I often say that I have seen it all. The horrors of this child abuse case defy that. The alleged actions of this defendant are among the most callous I have seen." Assistant Wayne County Prosecutor Tina Ripley was equally direct in court. Zemar King was a 9-year-old child who was treated like he was a piece of garbage, Ripley said. He deserved better. The charges filed against Brandy Pierce were extensive and serious. First-degree premeditated murder, felony murder, first-degree child abuse, tampering with evidence, and concealing the death of an individual. If convicted on the murder charges alone, Pierce faced life in prison without the possibility of parole. The defense, represented by attorney Raid Murad, noted at arraignment that Pierce had a history of mental health diagnoses and had not been receiving her medication. He asked the court to consider her mental state. The court denied bond regardless, citing both the severity of the allegations and the fact that Pierce had already demonstrated she was willing to leave the state. Not only is Ms. Pierce a danger to the community, Magistrate Burton said, but she's also a flight risk. After these egregious allegations happened, she left the state. Detroit Police Chief Todd Bettison called the case very shocking. The city's media covered it extensively. National outlets picked it up. The image that circulated most widely was a photograph provided by the Wayne County Prosecutor's Office. Brandy Pierce alongside a smiling young Zemar King, a boy with his whole life still ahead of him. The case raised immediate and urgent questions about the functioning of Michigan's child welfare system. When Zemar told CPS workers in April of 2024 that his mother was harming him, what happened next? Were home visits conducted? Was a safety plan put in place? Were his words documented and followed up on with the urgency they deserved? Those questions did not have immediate public answers, but they were being asked loudly by advocates, journalists, and members of the Michigan legislature. Zemar King had done what we tell children to do. He told a trusted adult. He used his words. He said, as clearly as a 9-year-old can say it, that he was not safe. And the system that was supposed to act on those words failed him in the most irreversible way possible. As of the time this script was researched, the case against Brandy Pierce was still moving through the Wayne County court system. A probable cause hearing was scheduled for March 7, 2025, with a preliminary examination set for March 13. The full legal proceedings were ongoing. But Zemar King is not ongoing. He was 9 years old. He liked things that 9-year-old boys like. He had a smile in that photograph. And he is gone, found in a shallow backyard grave, in the cold Michigan January, weeks after the last person who should have protected him allegedly placed him there. The Wayne County Prosecutor's Office has made clear that they intend to pursue the most serious charges available under Michigan law. The community has made clear that Zemar deserved better. And the investigators who worked this case, who dug into the records, who tracked Pierce from Detroit to Georgia, who pieced together the timeline of what happened in that house on Whittingham Drive, have made clear that they will not let this story be forgotten. Zemar King deserved to grow up. He deserved to be safe. He deserved to be heard. And in the end, the only people who truly heard him were the prosecutors and investigators who carried his words into a courtroom and refused to put them down. This case is a reminder that child protection is not a bureaucratic function. It is a life-or-death responsibility. And when it fails, the consequences are irreversible. If this story has moved you, please like this video and subscribe to Cold Case Time. Every subscription helps us keep bringing these important cases to the attention they deserve. And please, if you ever hear a child say they are not safe, take it seriously. Always. Case 3. Tanya Johnson. March 2, 2026. Detroit, Michigan, a strip mall parking lot at the 9700 block of Harper Avenue, near Gresham Avenue, on Detroit's east side. Wayne County Prosecutor Kim Worthy has prosecuted some of the most serious cases in Michigan history. She has stood before cameras many times and delivered statements about cases that shocked the conscience. But in March of 2026, Worthy said something that cut straight through even the most case-hardened observer in the room. The alleged facts of this case, Worthy said, are among the worst child safe storage cases that we have seen. This will affect these children forever. The loss of the life of one of their siblings in a closed compartment of the defendant's car cannot be unseen. That statement was about a 6-year-old girl, a child who lost her life in the back seat of her mother's minivan in a Detroit parking lot on a Monday afternoon because of a loaded handgun that was left where a child could reach it. Tanya Sharicenise Johnson was 41 years old and working as a DoorDash delivery driver on the afternoon of March 2, 2026. She had 5 children with her in her minivan, ranging in age from 2 years old to 11 years old. She pulled into the parking area of the Farmer John Food Center in the 9700 block of Harper Avenue to pick up a delivery order. It was a routine stop. She would be in and out quickly, she presumably thought. She left her 5 children in the vehicle. What she did not remove from the vehicle was the loaded handgun she kept there. According to Detroit police and the Wayne County Prosecutor's Office, the weapon, a loaded handgun, was left unsecured beneath the front seat of the minivan. Her 11-year-old son found it. According to investigators, the 11-year-old later told police that the gun had always been kept in the vehicle, but that he did not know it was loaded. He fired it. The bullet struck his 6-year-old sister in the back of the head. One of the other children ran into the restaurant to find their mother. Detroit police received the call at approximately 12:06 in the afternoon. Officers arrived and found the 6-year-old girl suffering from a critical gunshot wound to the head. She was transported immediately to a local hospital. She did not survive. By the time the full picture emerged, investigators had also found multiple unsecured firearms at Johnson's residence. The case was not an isolated lapse in judgment. It reflected a pattern of how these weapons were being stored in an environment with young children. Johnson's sister, Frederica Johnson, spoke to reporters after the arrest and painted a picture of a family in genuine grief. She said Tanya carried the weapon for her own protection while working as a delivery driver, a job that takes drivers through all kinds of neighborhoods at all hours of the day. She said the children were homeschooled and often accompanied their mother on her delivery route. She said the family was devastated. Nobody expected this to happen, Frederica Johnson said through tears. I lost a sister, and I lost a niece, and ain't no bounce back from this. Those words were heartbreaking, and they were true. There is no bouncing back from this. Not for the family, not for the 11-year-old boy who will carry what happened in that parking lot for the rest of his life, and certainly not for the 6-year-old girl who did not come home. First Assistant Detroit Police Chief Charles Fitzgerald noted at a press conference that the shooting was the 3rd incident of its kind in the preceding 2 weeks, children accessing unsecured firearms in Detroit. He made a point that investigators, prosecutors, and child safety advocates had been making for years, and that the Oxford High School shooting tragedy had finally pushed into Michigan law. The purpose of safe storage exists, Fitzgerald said. Secure your firearms. A little girl of 6 will no longer attend school. She won't grow up to join Detroit's police force or enter the media industry. It's not only heartbreaking, it could have been avoided. That last phrase, it could have been avoided, is the defining sentence of this case. Because unlike some of the tragedies that appear in a documentary like this one, the mechanism of this particular harm was entirely and unambiguously preventable. A gun lock costs less than $15. A lockbox costs less than $30. A trigger guard can be purchased at any sporting goods store. Michigan, following the Oxford High School shooting of 2021, passed safe storage legislation precisely to prevent situations like this one. The law existed. The tools to comply with it were accessible. And a 6-year-old girl still did not make it out of that parking lot alive. Tanya Sharice Johnson was charged with a safe gun storage violation, specifically, the charge of allowing a minor access to a firearm that resulted in a death. She was also charged with 3 counts of second-degree child abuse and 4 counts of felony firearm. Together, those charges carried the potential for nearly 20 years in prison. She was given a $30,000 cash surety bond and appeared in court via Zoom, where she entered a plea of not guilty and wiped away tears throughout the proceeding. Her attorney noted the circumstances: a working mother, a delivery driver, a woman trying to provide for 5 children, and asked the court to consider that context. The prosecutor's office was direct in its response. Context does not bring a child back. Securing a firearm in a vehicle with children present is not optional. It is the law. And when that law is violated, and a child does not survive as a result, there are criminal consequences. What makes this case particularly resonant in the context of Michigan's broader child safety landscape is the connection to the Oxford High School shooting. It was Ethan Crumbley, using a weapon his parents had purchased for him and failed to secure, who opened fire at Oxford High School on November 30th, 2021, and ended the lives of 4 students. The trauma of that event drove Michigan to pass stronger safe storage laws. And yet, just a few years later, in a parking lot on Harper Avenue in Detroit, a different set of children were left with a different unsecured weapon, and the outcome was the same kind of irreversible tragedy. The message from law enforcement, prosecutors, and child safety advocates in the wake of this case was unambiguous. If you own a firearm and you have children in your home or your vehicle, the responsibility to secure that weapon is absolute. It is not a suggestion. It is not a guideline. It is a legal and moral obligation. And the moment you walk away from an unsecured loaded weapon in the presence of a child, you have created a situation that no amount of grief or good intentions can undo. For the 5 children who were in that minivan on March 2, 2026, the 2-year-old, the 6-year-old who did not survive, the other siblings who watched everything unfold, the trauma of that afternoon will be with them for the rest of their lives. Children who witness incidents of this magnitude rarely emerge from that experience without lasting psychological effects. They will need counseling. They will need support. They will need the kind of sustained, compassionate intervention that child welfare systems too often fail to provide consistently. A 6-year-old girl deserved to come home from that parking lot. She deserved dinner that evening and school the next morning and a whole lifetime of ordinary days. That future was taken from her, not by malice, perhaps, but by a choice that should never have been made. And in Michigan, under the safe storage laws that were written in the shadow of Oxford, that choice carries criminal accountability. The case of Tanya Johnson is a case about gun safety, but it is also a case about the responsibilities that come with parenthood, with firearm ownership, and with the understanding that the choices adults make in the presence of children carry consequences that can never be undone. Before we continue, we want to remind you, if you are learning something from these cases, please like this video and hit the subscribe button on Cold Case Time. It costs you nothing and means everything to us. Let's keep going. Case 4. Jennifer Crumbley. November 30th, 2021, the date of the Oxford High School shooting. February 6th, 2024, the date of Jennifer Crumbley's conviction. April 9th, 2024, the date of her sentencing. Oxford, Michigan, Oxford High School, Oakland County. In the entire recorded history of American mass school violence, no parent had ever been held criminally responsible for a shooting carried out by their child, until February 6, 2024. On that date, in an Oakland County courtroom in Pontiac, Michigan, a jury returned a verdict that legal experts across the country described as historic, precedent-setting, and deeply significant. Jennifer Crumbley, the mother of Oxford High School shooter Ethan Crumbley, was found guilty on 4 counts of involuntary manslaughter. She became the first parent in the history of the United States to be convicted of this type of crime in connection with a school shooting committed by their child. The story of how that verdict came to pass begins on a cold Tuesday morning in late November of 2021. Ethan Crumbley was 15 years old on November 30th, 2021. He was a student at Oxford High School in Oxford Township, Michigan. In the months leading up to that morning, he had been showing signs of serious psychological distress. He had written in his journal about violent thoughts. He had drawn disturbing images depicting violence, death, and a figure shooting people, along with handwritten phrases asking for help and expressing desperation. His mental state had, by any reasonable assessment, been deteriorating. And the people who were legally and morally positioned to do something about it, his parents, had not gotten him the professional help he needed. On the morning of November 30th, school counselors called Jennifer and James Crumbley to the school after a teacher discovered that Ethan had drawn one of those disturbing images on a math worksheet. The drawing depicted a figure that appeared to be in distress, along with a gun and phrases that expressed violent and suicidal ideation. School officials testified later that they told the Crumbleys their son needed mental health attention. According to testimony, the Crumbleys said they needed to return to work and could not take Ethan home with them at that moment. School officials, expressing concern, allowed Ethan to remain at the school rather than requiring him to leave with his parents. That decision, by the school and by the Crumbleys, has been dissected in courtrooms, in legal journals, and in national media ever since. That afternoon, Ethan Crumbley went to a bathroom at Oxford High School. He retrieved from his backpack the Sig Sauer 9mm handgun that his parents had purchased for him just 4 days earlier as an early Christmas present. He walked back into the hallways of Oxford High School and opened fire. 4 students lost their lives that day. Madison Baldwin, Hannah St. Juliana, Tate Meyer, and Justin Schilling. All of them young. All of them with futures that were stolen from them in an afternoon of violence that lasted less than 5 minutes, but whose consequences will echo for generations. 7 other people were also wounded in the shooting, including a teacher. Ethan Crumbley was taken into custody that afternoon. He would later plead guilty to 1 count of terrorism causing death, 4 counts of first-degree murder, and 19 additional charges. He was sentenced to life in prison without the possibility of parole, the first time in Michigan history that a juvenile had received such a sentence. But the legal story did not end with Ethan. Wayne County, and then Oakland County, prosecutors made a decision that had never been made before in an American courtroom. They charged his parents. Jennifer Crumbley and her husband James Crumbley were both arrested in the days following the shooting, found hiding in a Detroit warehouse after warrants were issued for their arrest. Both were charged with 4 counts of involuntary manslaughter, 1 count for each student who lost their life. Prosecutors used a novel legal theory. They argued that the Crumbleys were so grossly negligent in their handling of their son's warning signs, and so irresponsible in their decision to purchase and provide him with a firearm despite those warning signs, that they bore criminal responsibility for the harm that followed. The theory was controversial. Legal scholars debated whether it could succeed, whether it set a dangerous precedent, whether it would survive appellate review. Parents across the country watched with deep unease. The defense argued that Jennifer Crumbley had no specific knowledge that her son intended to carry out a shooting. She could not, they said, be held responsible for actions she could not have predicted with certainty. The prosecution countered with the evidence. They showed the jury Ethan Crumbley's journals, in which he had written about violent desires, journals that were in the family home, potentially accessible to his parents. They showed the jury the drawing from the math worksheet that the Crumbleys had been called to the school to discuss that very morning. They walked the jury through the timeline of the firearm purchase. 4 days before the shooting, Jennifer Crumbley had been present at the gun shop where the Sig Sauer was purchased. She had, in at least one account, texted Ethan about the weapon, referring to it with enthusiasm. And when the Crumbleys were called to the school that morning to discuss Ethan's disturbing drawing and his apparent expressions of distress, they did not tell the counselors about the gun. They did not mention that their son had access to a firearm. They left the school and returned to work. Jennifer Crumbley took the stand in her own defense. She testified about her marriage, her relationship with her son, her unawareness of the depth of his distress. She admitted to an extramarital affair. She attempted to convey to the jury that she had been a present and engaged parent who simply had not seen the specific danger coming. The jury deliberated and returned a guilty verdict on all 4 counts. On April 9, 2024, Jennifer and James Crumbley were sentenced together in Oakland County Circuit Court. Judge Cheryl Matthews, who presided over both trials, sentenced each of them to 10 to 15 years in prison. Before delivering the sentence, she spoke words that became among the most quoted of the entire proceeding. "These convictions are not about poor parenting," Judge Matthews said. "These convictions confirm repeated acts, or lack of acts, that could have halted an oncoming runaway train. About repeatedly ignoring things that would make a reasonable person feel the hair on the back of their neck stand up." The families of the 4 victims were present in the courtroom for sentencing. They delivered impact statements that moved observers to tears. James Schilling, the father of Justin Schilling, spoke directly to the parents of the students whose children had survived the shooting and to the parents whose children had not. His grief was palpable, his composure remarkable. The Crumbleys, for their part, read prepared statements in which they expressed sorrow. James Crumbley told the families that he could not express how much he wished he had known what was coming. Jennifer Crumbley expressed her deepest condolences. Both began filling out paperwork for an appeal before they had left the courtroom. As of August of 2025, Jennifer Crumbley had filed a nearly 100-page brief with the Michigan Court of Appeals seeking to have her conviction overturned. Her attorney argued that she was under no legal duty to control her son's behavior, and that the prosecution had been, in his words, a sham. The appeal was ongoing. The legal debate about parental responsibility in the context of school violence, a debate that the Crumbley verdicts reignited at the national level, showed no signs of quieting. But for Madison Baldwin, Hannah St. Juliana, Tate Meyer, and Justin Schilling, The debate is abstract. They are not here to observe it. Their parents are. And the parents of Oxford High School survivors. Children who were in those hallways, who hid in classrooms, who heard the gunfire and did not know if they would see another day. Those parents live with the consequences of November 30th, 2021, every single day. The Crumbly case changed the American legal landscape. It established, for the first time, that parents of a school shooter can face serious criminal accountability for their role in enabling the conditions that made the shooting possible. Whether that precedent will hold, whether it will be expanded, whether it will deter other parents from similar patterns of neglect, those are questions that will be answered over the coming years and decades in courtrooms across the country. What is not in question is the devastating reality of what happened at Oxford High School. For young people went to school on a Tuesday morning in November and did not come home. Their names should be remembered: Madison Baldwin, Hannah St. Juliana, Tate Meyer, Justin Schilling. They were not abstractions in a legal debate. They were children, and they deserved better from every adult whose choices contributed to the circumstances of that day. If this case has made an impact on you, we ask you to like this video and subscribe to Cold Case Time. We tell these stories so they are not forgotten. Thank you for watching and for sharing. Case 5, Monique Dillard Bothuel. June 14, 2014. The date Charlie Bothuel V. was reported missing. June 25, 2014. The date he was found alive in the basement. February 20th, 2015. The date charges were filed. Detroit, Michigan, the 1300 block of Nicolay Place, Lafayette Park neighborhood. On the evening of June 14, 2014, a Detroit father called police to report that his 12-year-old son had gone missing. The father's name was Charlie Bothuel IV, and the boy he reported missing was his son, Charlie Bothuel V. The report triggered what would become an 11-day search, a search that involved the Detroit Police Department, the Michigan State Police, the FBI, and eventually the national media. The case was covered on cable news. It became a viral story, and it took one of the most stunning turns in the history of Detroit crime coverage. Charlie Bothuel V. was found alive on June 25, 2014. He was found in the basement of his own home, the same home where his father and stepmother lived, the same home that had already been searched multiple times, the same home that cadaver-sniffing dogs had been brought through as investigators desperately tried to locate the missing child. He had been there the entire time, hidden behind heavy boxes and a large drum, thin and frightened, in the very house where his father had called police to report him missing. The moment the discovery was made public became one of the most memorable in the history of the Nancy Grace television program. During a live broadcast on June 25th, Grace broke the news to Charlie Bothuel IV while he was appearing on the show. His reaction, his eyes darting, his hands raised, his apparent shock, was watched by millions of Americans and generated enormous debate about whether his response was genuine. But the shock of the discovery was quickly overshadowed by what investigators found when they looked more closely at the circumstances surrounding Charlie Bothuel V's presence in that basement. The boy was thin, noticeably, measurably thin. He had visible marks on his upper body. And as investigators spoke with him, as child welfare workers began assessing his condition, a picture emerged that was deeply troubling. Charlie told investigators that life inside the Nicolay Place home had been, in his words, a terrible place. He said he had been subjected to a punishing daily exercise regime that he was forced to complete twice a day, every single day, under threat of physical punishment. According to court documents and testimony, the morning and evening workouts included 100 push-ups, 200 sit-ups, 100 jumping jacks, 25 arm curls per arm using a 25-pound weight, and 5,000 revolutions on an elliptical machine. He was required to wake up at 5 in the morning to begin. If he failed to meet the expectations set for him, he said he was struck, sometimes with a PVC pipe, on his buttocks, his feet, his chest, his head, his thighs, his sides, and his arms. He said he had been sent to the basement as a form of punishment and ordered to remain there. Wayne County Prosecutor Kim Worthy announced charges in February of 2015. Both Charlie Bothuel IV and his wife, Monique Dillard Bothuel, were charged with 1 count of torture and 1 count of second-degree child abuse. It was, as Worthy herself noted, a historic moment for Wayne County. "We are thankful that the victim was found alive," Worthy said. This is the first time that the Wayne County Prosecutor's Office has charged torture for a living child. Based upon the allegations, if any case warrants child torture charges, this one certainly does. Monique Dillard Bothwell was 37 years old at the time of her arrest. She had been Charlie's stepmother for the period he lived in the Nicolay Place home. Court petitions filed in Wayne County's family court alleged that Dillard Bothwell had ordered the boy to complete the extreme daily workouts, had threatened him on multiple occasions, and had specifically ordered him to the basement as a disciplinary measure. She was also facing a separate probation violation charge stemming from an earlier illegal firearm purchase, which came before a judge just 2 days after the basement discovery became public. Both Dillard Bothwell and Bothwell IV were arraigned in 36th District Court. Bond was initially set at $500,000 cash or surety for each. They appeared by video from jail and entered not guilty pleas. A magistrate noted the severity of the allegations and expressed concern about the boy's welfare. What followed in the legal proceedings was complicated and, for many observers, unsatisfying. During the preliminary examination, a doctor who examined Charlie noted that his medical records from the hospital where he was taken after the basement discovery showed him to be well-nourished and hydrated, with no major injuries beyond a circular scar on his chest and scarring on his buttocks from what he said were beatings with the PVC pipe. Defense attorneys seized on this, arguing that the boy's physical condition undermined the prosecution's narrative. They suggested the boy had fabricated elements of his story and that he had voluntarily gone to the basement and could have left at any time. The judge hearing the preliminary examination agreed, at least in part. The torture charges were dismissed. The judge ruled that the evidence did not rise to the level required to support a torture charge as defined under Michigan law. The ruling was a significant legal victory for the couple. They cried with relief and hugged their attorneys. However, the second-degree child abuse charges survived the preliminary examination and were bound over for trial. Photos of Charlie's body, the testimony of medical professionals, and the boy's own statements were found sufficient to support those charges. In January of 2016, Charlie Bothwell IV pleaded guilty to a reduced charge of fourth-degree child abuse. Judge Margaret Van Houten sentenced him to 18 months of probation, anger management classes, and no contact with his son. It was a sentence that many observers felt did not reflect the gravity of what the boy had endured. The case against Monique Dillard Bothwell was ultimately dismissed. She did not stand trial on the child abuse charges. The prosecution's case against her did not survive the full legal process. For many people who followed this case, the outcome was deeply frustrating. A 12-year-old boy had told investigators that he had been forced into punishing physical regimes, struck with a PVC pipe, and confined to a basement. He had been found hidden in that basement during an 11-day search that involved law enforcement at multiple levels. And at the end of the legal process, his father received probation and his stepmother walked free. The case raised serious and still unresolved questions about what evidence is required to successfully prosecute child abuse allegations in Michigan courts, about the reliability and weight given to a child's own testimony, and about the protections that exist, or fail to exist, for children in homes where abuse allegations are made but difficult to prove beyond a reasonable doubt. Charlie Bothwell V's parental rights situation was also addressed in Wayne County Family Court. The state sought to terminate parental rights to multiple children in the household. The family court proceedings, conducted separately from the criminal case, addressed the welfare of the children who had been living in the Nicolay Place home. The basement boy story, as it became known in Detroit media, was ultimately a story about what happens when a child needs help and the systems around him are too slow, too uncertain, or too easily defeated by legal procedure to provide it in time. Charlie Bothwell V survived. He was found alive. But the trauma of what he described enduring in that home, and the trauma of watching his abusers face limited legal accountability, is not something that disappears simply because a case file is closed. The Detroit community and child advocates across Michigan responded to this case with renewed calls for stronger child abuse protections, clearer evidentiary standards that take children's testimony more seriously, and more robust oversight of families where abuse has been reported or suspected. Those calls continue today. Every child who is being harmed inside a home deserves a system that can act with the urgency and certainty that the situation demands. The case of Charlie Bothwell V. and of the woman charged alongside his father, Monique Dillard Bothuel, is a reminder that our legal standards, however necessary, can sometimes fail the very people they are designed to protect. Please like this video and subscribe to Cold Case Time if you believe every child deserves to be safe, heard, and protected. Your support keeps these stories alive and ensures these conversations continue. Hit that subscribe button right now. Case 6. Chelsea Duperon. March 13th, 2024. The date the harm occurred. March 16th, 2024. The date emergency services were called. July 29th, 2025. The date of sentencing. Wayne, Michigan, the 35,200 block of Phyllis Street, near Van Born and Wayne Roads. At approximately 5:19 in the morning on March 16th, 2024, Wayne Police Department officers were dispatched to a residence on Phyllis Street in the city of Wayne, Michigan. The call reported a child who was not breathing. Officers arrived to find an 8-year-old girl unresponsive in a bedroom. She had multiple severe injuries to her head and neck. Medics rushed her to a local hospital. She was pronounced gone upon arrival. Her name was Lila Castle. She was 8 years old. Her mother, Chelsea Renee Duperon, was 30 years old. And what investigators would piece together in the days that followed would lead Wayne County Assistant Prosecuting Attorney Aaron Wilmoth to stand before a judge and say these words. The sheer brutality that innocent 8-year-old Lila suffered on March 13th of 2024 is really like nothing I've ever seen in my 5 years of handling child abuse cases. When investigators arrived at the home on Phyllis Street, the scene told a story that Duperon could not convincingly explain away. Lila had been wearing a diaper, not because she was an infant, but because, as investigators determined, her condition following the assault had made it impossible for her to get herself to the bathroom. Duperon had put a diaper on her 8-year-old daughter rather than call for medical help. Officers noted severe swelling and bruising across Lila's head, face, and neck. The Wayne County Medical Examiner would later determine the cause of her passing to be massive blunt force trauma to the head, neck, and face, which had caused extreme brain swelling. The medical examiner also told prosecutors that if Lila had received medical attention on the day of the assault, March 13th, she would likely have survived. She was alive for 3 days after the assault. She lay in her bed while her mother went to a store, purchased diapers and Vaseline and heating pads and liquor, and came home. She could have been saved, Assistant Prosecutor Wilmoth said. Lila was just placed in a bed. Her mother went out to the store to get diapers because this child could not go to the bathroom. Diapers, heating pads, Vaseline, as well as some liquor for herself, while her daughter is lying in bed dying a slow death. The explanation that Chelsea Duperon offered when police arrived was, to put it plainly, extraordinary. She initially told investigators that Lila had fallen down the stairs. That account was quickly dismantled. The medical examiner told investigators that the injuries they observed were not consistent with a fall downstairs. There were no impact patterns, no distribution of injuries that you would expect to see if a child had tumbled down a staircase. Duperon then changed her story. She told investigators that she did not entirely remember what had happened. Then she told them something else, something that caused the officers in the room to exchange glances. She told them that there were bad spirits in the home, that a mysterious woman had appeared in the basement, that something had come over her, that it was not her, not entirely. I swear to God this is not me, Duperon reportedly told investigators. This sounds crazy, but there's bad spirits. Sergeant Jason Walters, who was present during the interview, later testified about those statements at the arraignment. He told the court that Duperon had described the presence of a spirit or ghost that she said had led her to harm her daughter after the child began acting, in Duperon's words, crazy. Duperon's boyfriend, who was living in the home, provided investigators with details that helped fill in the timeline. He said he had come home from work on Wednesday, March 13th, and found Lila on the kitchen floor, severely injured. He said the child was responsive and was talking. He picked her up and carried her to a bed. He did not call 911. His explanation was that she was not his daughter and he had not known what to do. He later told investigators that Lila, while he was carrying her, told him she had been listening to music when Duperon attacked her, that the child had tried to hide, that her mother had found her and hurt her while pouring water on her. The prosecution's case was built on this timeline, on the medical examiner's findings, On the security camera footage from the store that showed Dupron purchasing items while Lila lay dying, and on the physical evidence at the scene. Neighbors, interviewed by local media after the arrest, described hearing raised voices from the home and expressing concern for Lila before the tragedy. One neighbor, Jason Willoit, said he had previously gone to police with video footage from his security cameras showing concerning behavior at the property. Chelsea Dupron was arrested and charged with felony murder and first-degree child abuse. She appeared at her arraignment and entered a plea of not guilty. She was held without bond. A psychological evaluation was ordered. Video of the arraignment showed Dupron appearing to smirk at one point during the proceedings, an image that was widely circulated in media coverage and generated significant public reaction. The legal process moved through 2024 and into 2025. On July 1, 2025, Chelsea Renee Dupron, now 31 years old, pleaded guilty to second-degree murder. As part of the plea agreement, the charges of felony murder and first-degree child abuse were dismissed. On July 29, 2025, she appeared for sentencing in Wayne County Circuit Court. The judge sentenced her to 28 to 50 years in prison. Both crimes, felony murder and first-degree child abuse, carry the potential for life imprisonment, and the plea deal represented a negotiated resolution rather than the maximum possible outcome. But 28 to 50 years meant that Chelsea Dupron, absent extraordinary circumstances, would not be leaving prison for decades. Lila Castle had been described by neighbors as a fantastic and lovable child. Funny, talkative, cheery, always happy when she was around. A little girl who made an impression on the people around her. A little girl who mattered. She was 8 years old. She should have had a whole life ahead of her. The case is a reminder of the absolute urgency of acting when a child may be in danger. Neighbors in this case saw things that concerned them. They reported concerns. The systems around Lila did not catch this in time. And 3 days, 72 hours during which Lila was still alive, passed without anyone calling an ambulance. Child safety advocates who have studied cases like Lila's make a consistent point. When a child is injured, every moment matters. Medical intervention is not something that can be offered retroactively. The only protection a child has when an adult fails them is the intervention of someone else, a neighbor, a teacher, a family member, a passerby, who notices, who acts, and who refuses to walk away. Lila Castle deserved every one of those people to show up in time. She deserved to grow up. And the sentence handed to her mother, while it will never restore what was lost, represents the accountability that the law can offer, even when everything else has already been taken. If you believe in justice for children like Lila, please like this video and subscribe to Cold Case Time. Your support means the world to us and keeps this work going. Subscribe now and share this story. Case 7, Paige Boney. November 7th, 2024. The date emergency services were called. December 24th, 2025. The date of sentencing. Sturgis Township, Michigan, Memory Lane Mobile Home Park, St. Joseph County. At approximately 12:47 in the afternoon on November 7th, 2024, deputies from the St. Joseph County Sheriff's Office were dispatched to Memory Lane Mobile Home Park in Sturgis Township, Michigan. The call had come from a young woman who reported that her 2-year-old daughter would not wake up. The child's name was Octavia Boney. She was 2 years old. She loved cheese puffs. She watched Peppa Pig and Mickey Mouse. She was, according to everyone who knew her, a happy, mischievous little girl, vibrant and full of life, always smiling, always wanting to be carried around by someone who loved her. Her aunt described her as a child who posed for photographs instinctively, as if she already understood that life was something worth documenting. When St. Joseph County deputies arrived at Memory Lane Mobile Home Park that Thursday afternoon, they found Octavia unresponsive. Despite life-saving efforts at the scene, she could not be revived. She was pronounced gone. An autopsy was ordered. The woman who had made the 911 call was Octavia's mother, Paige Nicole Boney. She was 21 years old. She had called the dispatcher and told them her daughter would not wake up. She had seemed concerned, according to investigators. She had followed the dispatcher's instructions during the call. But the more closely authorities looked at the evidence at the scene, the more clearly it became that what had happened to Octavia Boney was not an accident and not a medical event. The autopsy confirmed their suspicions. The cause of Octavia Boney's passing was suffocation. Paige Boney was initially arrested on an involuntary manslaughter charge. Within days, the St. Joseph County prosecutor upgraded those charges to open murder. Boney was denied bond. She remained in the St. Joseph County Jail. As the investigation deepened, prosecutors assembled a picture of what had happened in the hours before Octavia's death, a picture that St. Joseph County Prosecutor Deborah Davis would later describe in court as unconscionable. According to the findings presented at sentencing, Paige Boney had given her 2-year-old daughter a significant amount of melatonin gummies on the morning of November 7th, described by prosecutors as a handful, at nearly 3 times the concentration that would be considered a peak adult dose. The purpose, according to the investigation, was to force Octavia to sleep so that Boney could use her phone to exchange messages with her boyfriend, scroll through TikTok, and prepare food for herself. When Octavia would not go to sleep as Boney wanted her to, Boney allegedly held her daughter face down into the couch cushions and pressed her down until the child stopped resisting. Trying to force this child back to sleep so she could text back and forth with her boyfriend, play on TikTok, and make herself something to eat, Prosecutor Davis told the court, is unconscionable. Octavia Boney was 2 years old. She was pressing against a couch cushion because she would not take a nap. The 911 call that Boney placed was released publicly in the weeks following the arrest. Throughout much of the recording, the dispatcher can be heard attempting to walk Boney through life-saving measures. The call became part of the evidentiary record in the case. There was also a second individual charged in connection with Octavia's passing. Frederick Nelson, 32 years old of Battle Creek, was charged with felony murder, aiding in strangulation, and tampering with evidence in connection with the same case. Nelson posted bond following a preliminary examination and faced a separate trial. Boney agreed to cooperate and testify truthfully against Nelson as part of her plea agreement, a decision that shaped the resolution of her own case. In July of 2025, Paige Nicole Boney entered a plea of no contest to first-degree child abuse and assault with intent to do bodily harm. In exchange, the open murder charge and the conspiracy charge were dismissed. The community's reaction to the dismissal of the murder charge was swift and strong. Many who had followed the case felt that the plea deal did not fully reflect the magnitude of what had happened to Octavia. On December 24, 2025, Christmas Eve, Paige Nicole Boney appeared in St. Joseph County Circuit Court for sentencing. Judge Paul Stutzman sentenced her to 18 years and 9 months to 45 years in prison, noting the severity of the harm and the particular vulnerability of the victim. The sentence was at the top end of Michigan's sentencing guidelines. Boney did not address the court. Her parental rights to her older son had already been terminated earlier in the proceedings. Under Michigan Department of Corrections records, Boney will not be eligible for parole until August 6, 2043. Her maximum discharge date is November 6, 2069. Octavia's grandfather, Charles Boney, Paige's father, spoke to reporters in the immediate aftermath of his granddaughter's passing and described the experience as waking up in a nightmare he could not escape. His wife, Susan Boney, said she was in complete disbelief. She described Paige as someone who had never previously raised a hand to her children. The family's grief was compounded by the complexity of mourning a grandchild while simultaneously processing what their own daughter had done. Octavia's aunt started a GoFundMe to help with funeral costs. In her fundraising message, she wrote that Octavia had been deeply loved by everyone who knew her. The community rallied around the effort. More than $3,000 was raised in days. Octavia deserved more, Octavia's aunt said in a public statement. I know there were many people that loved Octavia, and all her mom had to do was reach out to one of us. Anybody would have helped instead of what had happened to her. That statement is one of the most important things anyone said in this entire case. Because the support was there. The family was there. There were people who would have helped, who would have taken Octavia for a few hours, who would have given Paige a break, who would have made sure the child was safe. The help was within reach. It was never asked for. Instead, a 2-year-old girl who loved cheese puffs and Peppa Pig and the feeling of being carried by people who loved her took a nap that she never woke up from. The case of Octavia Boney is a case about a failure of judgment that cost a child her life. But it is also a case about the importance of community, of reaching out for help, of understanding that the pressures of parenting, particularly for young, isolated, unsupported parents, can build to breaking point without intervention. Child welfare advocates consistently emphasize that the resources available to parents in crisis are underutilized because the stigma around asking for help is too high and the accessibility of those resources is too low. Parenting is hard. Parenting a toddler is exhausting. But exhaustion is not a justification, and a nap is not something a child should have to risk their life for. Octavia Boney was 2 years old and full of life. She deserved every single day she did not get to have. If Octavia's story has touched your heart, please like this video and subscribe to Cold Case Time. Every subscriber helps us make sure that stories like Octavia's are told with the care and respect they deserve. Subscribe now. Case 8. Valerie Hamilton. January 22, 2023, the date Ethan Belcher lost his life. September 25, 2024, the date of conviction. October 11, 2024, the date of sentencing. Detroit, Michigan, the 14,600 block of Spring Garden Street, near 7 Mile Road and Chalmers Street, on Detroit's east side. In the annals of Wayne County child welfare cases, there are cases that test the endurance of everyone who encounters them. Cases that make jurors cry. Cases that make prosecutors pause mid-sentence. Cases that make investigators, people trained to maintain professional composure in the face of the worst human behavior, lose that composure in the break room after the workday ends. The case of Ethan Belcher is one of those cases. Ethan Belcher was 5 years old. He loved his brother. He had a name that people knew him by, not just Ethan, but probably a nickname too, something his siblings called him, something that made him laugh. He was a little boy who should have been going to kindergarten, learning to read, discovering the world. Instead, he spent his final months in conditions that Wayne County Assistant Prosecutor Matthew Makepeace, in his closing arguments, said could only be described as somewhere between an abandoned home and a construction site. The house had exposed walls. Some windows were boarded over. And in the basement of that house, where sewage water had accumulated and the smell of waste permeated everything, Ethan and his younger brother were forced to sleep. The home was on Spring Garden Street in Detroit. The woman who lived there was Ethan's biological mother, Valeria Lynn Hamilton, who was 27 years old at the time. The man who lived there alongside her was her partner, Shane Robert Shelton, also 27, who was Ethan's stepfather. Together, according to prosecutors, they ran a regime of systematic abuse inside that home that defied description. Ethan had over 100 cigarette burns on his body. He had frostbitten feet. He was missing a toe, an injury that had never received medical attention and had been left to deteriorate. He had been struck with a pipe, a fly swatter, and a belt. He had ligature marks, markings consistent with having been bound at the wrists and ankles. He had puncture wounds. He had a fractured rib. He had a dislocated hip. He had a severe cut between his toes. His knee was swollen. When investigators examined the small, unfinished closet where he and his brother had been forced to sleep, the blanket they found there was damp and smelled of urine. His younger brother, 3 years old, had also been subjected to severe physical harm. Both children had frostbitten toes. Both had been forced into the sewage-filled basement. The 3-year-old would survive. Ethan would not. On the afternoon of January 22, 2023, a Sunday, Detroit police received a call at approximately 1:07 in the afternoon from the Spring Garden Street address. Officers arrived and encountered medical personnel who were already loading Ethan into an ambulance. He was transported to a nearby hospital. He was pronounced gone upon arrival. The medical examiner determined that Ethan had died from blunt force trauma and sharp force injuries, with complications from sepsis and pneumonia. The sepsis and pneumonia, the medical examiner noted, would not have occurred if Ethan had not been subjected to the sustained harm that preceded his death. In other words, the injuries he had accumulated over months, the untreated wounds, the infections, the physical damage, had created the conditions for the organ failure that ultimately ended his life. Ethan Belcher was 5 years old. What made this case even more devastating was what investigators discovered when they looked backward. Ethan had not been invisible to the system. His family had tried to get him help. His paternal aunt, Ashley Belcher, told investigators and later told the media that she had reported the abuse to Child Protective Services the prior year. She said she had photographs. She said she had taken those photographs to a hospital herself. She said she had filed a police report with Lincoln Park Police in 2021. Lincoln Park Police Chief Raymond Waters confirmed that an incident had been investigated in 2021 in which Ethan had suffered injuries. The children had been temporarily removed and placed with their grandmother. A warrant request had been submitted to the Wayne County Prosecutor's Office for review. The warrant was denied. The children went back. They went back to the house on Spring Garden Street. They went back to Hamilton and Shelton. And more than a year later, Ethan Belcher was carried out of that house in an ambulance and did not survive. "We could have saved his life," Ashley Belcher told Local 4. "I had pictures. I took them to the hospital myself." Wayne County Prosecutor Kim Worthy filed charges against both Valeria Hamilton and Shane Shelton. Both were charged with felony murder, torture, conspiracy to commit torture, and 2 counts of first-degree child abuse. They were tried separately before separate juries. During the trials, jurors were shown evidence that included text messages between Hamilton and Shelton. In those messages, Shelton referred to the children in dehumanizing language and told Hamilton to harm them. In one text, Hamilton wrote that she would cause the children severe harm, words that were read aloud in court and that multiple jurors later said remained with them long after the verdicts were delivered. The evidence presented at trial included photographs of Ethan's injuries, photographs that the assistant prosecutor said reflected a child who, in some of the images, was virtually unrecognizable as the boy he had once been. Jurors cried during the presentation of that evidence. One juror later told reporters they had not been able to fully process what they had seen during the proceedings. On September 25, 2024, both Valeria Hamilton and Shane Shelton were found guilty by their respective juries of all charges. On October 11, 2024, they were sentenced together in Wayne County Circuit Court before Judge Darnella Williams Claiborne. Both received life in prison without the possibility of parole. Before sentencing, multiple family members delivered victim impact statements. Ashley Belcher addressed the court and said that the kids had been failed by so many people, including their parents. Deborah Warren, the foster mother of one of Ethan's siblings, read a letter from the child. A letter in which the boy questioned whether Hamilton had ever truly loved him and concluded that she had not, because she had only ever thought about herself. A foster father described the surviving 3-year-old's ongoing struggles. The child who had called Hamilton and Shelton by the names Bad Man and Mean Girl, who had seemed initially not to recognize his own given name because he had only ever been addressed in degrading terms, who had been surprised to learn that his foster parents intended to call him by his real name. "He struggles every day from the trauma he experienced," Ashley Belcher told the court. The family of Ethan Belcher filed a civil lawsuit against the Michigan Department of Health and Human Services in January of 2026, alleging that CPS investigators had failed to properly investigate the reported abuse in 2021, had failed to ensure that Shelton participated in required services, and had closed the case in violation of Michigan law. The lawsuit alleged that Ethan and his brother would not have endured years of harm without the state's failure to act. Senator John Rinstad of Oakland County introduced legislation in the wake of Ethan's death that would allow lawmakers and media greater access to CPS case files, arguing that transparency was essential to identifying the systemic failures that allowed cases like Ethan's to fall through the cracks. "When you get a look at the file," Rinstad said, "you could sit down with CPS and say, how in the hell is this happening? How does this child get hurt head to toe and you're returning them back and back to the same people that did this?" The legislation was still working its way through the Michigan legislature as of early 2026. Ethan Belcher deserved to be 5 years old in a safe home. He deserved kindergarten and a first bike and the kind of ordinary childhood that most people take completely for granted. He deserved adults in his life who chose to protect him rather than harm him, and he deserved a system of child protection that acted on the warnings he and his family gave it. He had none of those things. And the people who failed him, all of them, not just Hamilton and Shelton, but every system that received a warning and did not respond adequately, carry a portion of the accountability for what happened on Spring Garden Street. Life without parole for Valeria Hamilton and Shane Shelton is the law's most severe response. It is a statement that what was done inside that home was among the most serious violations of human dignity and child safety that a court can formally recognize. It is not enough. Nothing is enough. But it is what justice, imperfect and delayed, looks like in a case like this one. If this case has stirred something in you, Please like this video and subscribe to Cold Case Time. We tell these stories because children like Ethan deserve to be remembered. Hit subscribe now and help us keep telling these stories. Case 9, Mitchell Blair. August 20th, 2012. The estimated date 9-year-old Stephen Barry lost his life. May 25th, 2013. The estimated date 13-year-old Stony Blair lost her life. March 24th, 2015. The date the bodies were discovered. July 17th, 2015. The date of sentencing. Detroit, Michigan. The Martin Luther King Apartments, east side of Detroit. There are cases that define a city's relationship with its own darkness. Cases that become reference points, moments before and after which nothing in a community is quite the same. For Detroit, the case of Mitchell Blair is one of those cases. It is, by virtually any measure, the most infamous Detroit murder case in modern history. It shocked the country when it was revealed in the spring of 2015. And the details that emerged in the weeks and months that followed, in courtrooms, in child welfare hearings, in medical examiner reports, remain almost impossible to fully absorb, even years later. Mitchell Blair was 35 years old in March of 2015. She was a mother of 4 children, 2 daughters and 2 sons. She lived with all 4 of her children in an apartment at the Martin Luther King Apartments complex in Detroit. On the outside, to the people around her, she was a mother managing a household. Her children did not attend school. She had withdrawn them. When neighbors asked about the whereabouts of her younger children, she always had an explanation. Always an answer. Always a reason why they were not around. On March 24th, 2015, a court officer arrived at the Martin Luther King Apartments to carry out an eviction. The family had not been paying rent. The officer, accompanied by others handling the eviction, began the process of removing possessions from the apartment. And then they found the freezer. Inside a standalone deep freezer in the apartment, wrapped in plastic, were the bodies of 2 of Mitchell Blair's 4 children. Investigators would later identify them as Stephen Gage Barry, who had been 9 years old when he lost his life, and Stony Ann Blair, who had been 13 years old when she lost her life. They had been in that freezer for nearly 3 years. Stephen had been placed there in August of 2012. Stony had been placed there in May of 2013. They had been there, in that apartment, while their 2 surviving siblings went about the daily rhythms of life in the same space. They had been there while neighbors went about their days in the same building. They had been there while school officials presumably wondered why the Blair children had stopped attending. They had been there, and no one had known. The medical examiner was called. The bodies had to be thawed, a process that took 3 days before autopsies could be conducted. The results of those autopsies were devastating. Stony Ann Blair had died from multiple blunt force injuries. Stephen Gage Barry had died from multiple blunt force and thermal injuries. Thermal injuries, meaning he had been subjected to scalding with hot water as part of what was done to him. Both deaths were confirmed as homicides. As the investigation expanded, the surviving eldest daughter of Mitchell Blair, 17 years old at the time of the discovery, provided investigators with information about what had occurred inside that apartment. The details she described were among the most disturbing in the history of Wayne County child welfare. According to a petition filed in juvenile court related to the termination of parental rights, Blair had subjected her children to a pattern of severe physical harm over an extended period. Stephen had had plastic bags placed over his head and had been made to breathe through them. He had been subjected to scalding water that caused his skin to deteriorate. A belt had been wrapped around his neck. He had been forced to consume dangerous household substances. The eldest daughter said she herself had been harmed with a hot iron and had had rubbing alcohol poured over her wounds. Mitchell Blair, when confronted with this evidence, did not deny it. She admitted it. She provided her own account of why she had done what she did. She told investigators, and later told the court, that Stephen and Stony had sexually harmed her youngest child, a claim that the prosecutor's office stated was entirely unsubstantiated by any evidence. Blair said that what she did was a form of justice for her youngest son. The legal proceedings that followed were conducted with remarkable swiftness by Wayne County standards. Wayne County Prosecutor Kim Worthy, who charged Blair with 2 counts of felony murder, 2 counts of premeditated first-degree murder, and 1 count of torture, along with additional counts of child abuse, described the case in terms that made clear how seriously the office viewed it. In June of 2015, Mitchell Blair appeared before Wayne County Circuit Court Judge Dana Hathaway and entered guilty pleas. She pleaded guilty to 2 counts of first-degree murder. At her sentencing on July 17, 2015, Blair stood before Judge Hathaway and addressed the court. What she said, the words she chose to deliver in a public courtroom while facing a judge, left observers in disbelief. She said she did not feel remorse. She said the children she had harmed had no remorse for what they allegedly did to her youngest son. She said that if she had the opportunity to do it again, she would. She described Stephen and Stoney as demons. If I had a chance to do it again, I would, Blair told the court. I do not feel any remorse for what I did to Stoney because she had no remorse for what she did. Judge Dana Hathaway did not let those words stand without a response. Before delivering her sentence, the judge told Blair directly, "You imposed the death penalty on your own children. As a mother, one of your primary responsibilities was to protect your kids. You created a house of horrors for your 4 children. Your children lived in fear of you." Mitchell Blair was sentenced to life in prison without the possibility of parole. She has been incarcerated at a Michigan State Correctional Facility since that day. Her visitation rights to her 2 surviving children were suspended. A subsequent hearing before Wayne County Family Court Judge Edward Joseph resulted in the permanent termination of her parental rights to all of her surviving children. Wayne County Prosecutor Kim Worthy delivered a statement after the sentencing that reflected both the enormity of the case and the exhaustion of all who had been involved in bringing it to this moment. This sentence today brings to a close the tragic and shocking set of circumstances surrounding the very short lives of Stoney Blair and Stephen Berry, Worthy said. There were no winners, only losers. I truly hope these children can finally rest in peace. No winners, only losers. That sentence is, perhaps, the most accurate summary of what the Blair case represents. It is not a story with a hero who arrives in time. It is not a story where a warning sign was acted upon. It is a story where 2 children, 9 and 13 years old, disappeared from the world entirely, and no one who was positioned to notice acted in time to change what happened to them. Their fathers were largely absent from their lives. Their mother had pulled all 4 children out of school, removing the daily institutional contact that might have prompted someone to ask where they were. Neighbors noted that they had not seen the younger children in a long time, but accepted the explanations Blair provided. The apartment building went about its business. And inside one unit, a deep freezer held a secret that lasted nearly 3 years. The Blair case produced an enormous public outcry in Detroit and across the country. It led to renewed calls for stronger school attendance monitoring as a child welfare tool, for better coordination between housing authorities and child welfare agencies, and for mandatory reporting systems that create overlapping accountability rather than single points of failure. Most importantly, it is a case that refuses to leave the conscience. Stephen Gage Berry was 9 years old. Stoney and Blair was 13 years old. They were children who deserved to grow up, who deserved someone to advocate for them with the ferocity that their circumstances demanded. They did not get that. And the woman who was supposed to be the primary source of their safety was instead the source of their greatest and most irreversible harm. Mitchell Blair will spend the rest of her life in prison. There is no parole in her future. There is no release date on her calendar. The sentence she received is the law's clearest statement that what was done in that apartment on the east side of Detroit was among the most serious violations of human life and dignity that can be committed. Stoney Blair and Stephen Berry deserve to be remembered with the dignity and compassion that their short lives deserved and did not fully receive. They are not footnotes in a true crime story. They are children, and they will always be children, frozen at 9 and 13, in a city that failed to hear them while they were still alive to be heard. Please like this video and subscribe to Cold Case Time. Every view, every like, every subscription helps us keep telling the stories of victims who can no longer speak for themselves. If these children moved you today, hit that subscribe button and ring that bell. They deserve to be remembered. Case 10, Priyanka Chakraborty. February 6, 2015. The date the child was found unresponsive. October 3, 2015. The date of the verdict. Detroit, Michigan. A residence on Sobieski Street, east side of Detroit. The final case in today's documentary is one that differs in a significant and important way from the others you have heard. It is a case that entered the criminal justice system as a murder charge and exited that system through one of the most complex and least commonly invoked legal conclusions available under American law. It is a case about a mother, a child, a tragedy, and the deeply difficult intersection of mental illness, criminal responsibility, and justice. Priyanka Chakraborty was 26 years old in February of 2015. She was living on Sobieski Street on the east side of Detroit with her young son. His name was Amraj Chakraborty, and he was 2 years old. On the morning of February 6, 2015, someone called for help from that Sobieski Street address. When emergency responders arrived, they found 2-year-old Amraj unresponsive. He was transported immediately to a local hospital. He could not be revived. The child was pronounced gone. An autopsy was conducted by the Wayne County Medical Examiner's Office. The cause of death was determined to be asphyxia, meaning Amraj had been deprived of the oxygen required to sustain his life. The manner of death was ruled a homicide. On February 9, 2015, the Wayne County Prosecutor's Office filed charges against Priyanka Chakraborty. She was charged with first-degree murder, felony murder, and first-degree child abuse. She faced life in prison without the possibility of parole if convicted as charged. The case was, on its surface, straightforward in the worst possible way. A mother, a 2-year-old child, a medical examiner's ruling of homicide, and the weight of the criminal justice system bearing down. But Priyanka Chakraborty's case was not going to resolve itself in the way that most cases of this kind resolve. At her early court appearances, the court ordered a psychological evaluation. Detroit District Court Judge Ronald Giles, observing Chakraborty's behavior and hearing from legal representatives about her condition, referred her for a mental competency examination in February of 2015. Physicians and mental health professionals were brought in to assess whether she was mentally competent to stand trial, meaning whether she was capable of understanding the charges against her and assisting in her own defense. The evaluation concluded that she was not. In April of 2015, she was found mentally incompetent to stand trial. She was ordered to receive mental health treatment. The criminal proceedings were paused while that treatment was administered and her competency was reassessed. Eventually, the case moved forward, not to a traditional trial, but to a formal legal determination on the question of her criminal responsibility at the time of the offense. The distinction matters enormously in American law. Competency to stand trial is about a defendant's mental state during legal proceedings. Criminal responsibility, or, in common terminology, insanity at the time of the offense, is about the defendant's mental state at the moment the alleged crime took place. In this case, the legal system determined that Priyanka Chakraborty, at the time that Amraj lost his life, did not meet the legal standard required for criminal culpability. On October 3, 2015, she was found not guilty by reason of insanity. That verdict, not guilty by reason of insanity, is among the most misunderstood outcomes in the American legal system. It does not mean that nothing happened. It does not mean the child did not lose his life. It does not mean the harm was not real or that the loss was not devastating. What it means, in precise legal terms, is that the defendant, at the time of the alleged offense, was suffering from a mental disease or defect that rendered her unable to appreciate the nature of her actions or to understand that those actions were wrong. It is a verdict that the legal system reaches rarely and only after extensive professional evaluation. It is a verdict that, paradoxically, can result in longer-term institutional commitment than a criminal sentence in some cases, because a finding of not guilty by reason of insanity typically results in mandatory placement in a psychiatric facility until the individual no longer poses a danger to themselves or others, a determination that is made and reviewed by medical professionals and courts over time. Priyanka Chakraborty was not released. She was not acquitted in the way that term is commonly understood. She was directed into the mental health system, into a form of institutionalized care that is designed to address the underlying illness rather than impose punitive incarceration. The case of Priyanka Chakraborty and the tragic loss of Amraj Chakraborty raises profound questions that do not have easy answers. Questions about how the criminal justice system should respond when mental illness is genuine and severe. Questions about what justice means when a traditional verdict is legally unavailable. Questions about how communities can better identify parents in mental health crisis before a tragedy occurs, before a 2-year-old child pays the ultimate price for a system's failure to intervene earlier. Mental illness is not a character flaw. It is not a moral failing. It is a medical condition, one that can, in its most severe forms, cause a person to lose connection with reality so completely that their behavior becomes incomprehensible by any ordinary standard. And the tragedies that can follow when that level of illness goes unrecognized or untreated are among the most devastating that a family, a community, and a legal system can be forced to confront. Amraj Chakraborty was 2 years old. He did not have the ability to advocate for himself. He was dependent, as all 2-year-olds are, on the adults around him to keep him safe and to recognize when something was dangerously wrong. That protection was not available to him when he needed it most. And no legal verdict, not a conviction, not a finding of not guilty by reason of insanity, changes what was lost on that February morning in 2015. The case is a reminder that child safety requires attention at the level of mental health as much as at the level of criminality. Parents who are in psychological crisis, who are experiencing symptoms of serious mental illness, need access to intervention, evaluation, and treatment before a tragedy unfolds. The resources exist. The hotlines exist. The psychiatric emergency services exist. But they only work when someone reaches out to use them, or when a system detects the warning signs in time and responds. If you are someone who is struggling with your mental health, or if you know a parent or caregiver who appears to be in crisis, the resources available to you include the National Alliance on Mental Illness Helpline at 1-800-950-6264 and the Child Help National Child Abuse Hotline at 1-800-422-4453. These calls are confidential. They are free. And they can be the difference between a family that gets help in time and a family that does not. Amraj Chakraborty deserved to grow up. He deserved all the ordinary days that 2-year-olds have ahead of them. The first day of school, the first best friend, the whole enormous world waiting to be discovered. None of that was available to him. And the responsibility that falls on communities, on health systems, and on anyone who recognizes the signs of a caregiver in crisis is to act before a child has to pay that price again. These 10 cases, from Arizona to the east side of Detroit, from 2012 to 2026, are connected by more than geography or subject matter. They are connected by a common, painful truth, that the most vulnerable people in our society are often the least protected, and that the systems we have built to safeguard children can and do fail in ways that have permanent, irreversible consequences. Some of the women in this documentary committed premeditated acts of profound cruelty. Some made choices driven by desperation, poverty, mental illness, or a catastrophic failure of judgment. Some cases ended with life sentences. Some ended with verdicts that left communities frustrated and grieving. All of them left children, or the memory of children, at the center. The names of the children in this documentary deserve to be remembered. Zemar King, Lila Castle, Octavia Boney, Ethan Belcher, Stoney and Blair, Stephen Gage Berry, Amraj Chakraborty, the 6-year-old daughter of Tanya Johnson, the 4 students of Oxford High School, Madison Baldwin, Hannah St. Juliana, Tate Meyer, and Justin Schilling, and Charlie Bothuel V., who survived, and who carries with him the weight of everything that happened in that house on Nicolay Place. These are not names that belong in footnotes. They are names that belong in our hearts, in our conversations, and in the policy discussions that determine how this country protects its most vulnerable citizens. If this documentary has done anything today, we hope it has reminded you that child safety is a community responsibility. That warning signs matter. That when a child reaches out for help, the way Zemar King reached out to a CPS worker and told her his mother wanted to harm him, the response of the adults around that child is everything. Please reach out to the Child Help National Child Abuse Hotline at 1-800-422-4453 if you have any concerns about a child's safety. Your call could change everything. Thank you for watching Cold Case Time. If this documentary has informed you, moved you, or made you think, we ask you to do 2 simple things. Like this video so that more people can find it, and subscribe to our channel so you never miss a story. We will keep telling these stories. We will keep saying these names. And we will keep asking the questions that these cases demand, because the children who did not survive deserve nothing less And the children who are still out there, waiting for someone to notice, deserve everything more. Like, comment, and hit the subscribe button, and we will see you on the next episode of Cold Case Time.